Ladies and gentlemen, good afternoon and thank you for taking the time out to be with us today. My name is Surbhi Kejriwal and I'm a partner in Khaitan's M&A and Corporate Group. A very warm welcome to each of you to this webinar, wherever in the world you may be. Some of you may know that we've been hosting a rather successful M&A Master Series this year. This is our fourth webinar in the M&A Master Series and we look forward to your presence throughout the rest of the series. We've been thrilled with the response that we've received for this M&A Master Series. We are very grateful to all our clients and associates for your continued patronage, and we look forward to hosting many such series for you in the coming future. May we go to the next slide? As you can see, our topic for this webinar is cyber and data security issues in M&A transactions. The format will be a presentation on the topic by our expert Supratim, followed by an audience Q&A session. We've already received several audience questions from several of you, and while the presentation is on, if you have any further questions, please do utilize the facility on the portal to submit those questions to us. We will try our best to take up each and every question. However, due to time constraints, if we are unable to do so, we will respond to each of those offline. After the webinar, we will send you a copy of the presentation, summary notes, as well as the key issues, and a link to the recording of this webinar. Maybe go to the next slide, please. Now, I would just take a couple of minutes to set the context of why is it that we're picking this topic, cyber and data security issues in M&As. This issue has become very, very significant and important in recent times in M&A transactions. Now, whether or not data is the new oil remains to be seen. Data definitely is the newest form of asset for companies. In view of increasing value attributed to data, its collection, utilization, dissemination, and consequent monetization in businesses of various kinds, combined with new regulatory regimes around the world, regulating these aspects contribute to why this data security has assumed significance in M&A transactions. As is often the want, new asset classes call for newer, complex, and untested regulations. These regulations seek to impose significant penalty on companies, prescribe codes on how data needs to be dealt with, and have a far-reaching consequence when parties are stitching together deals. Protecting data has never been more important than it is today, and the need for companies to implement systems to secure this data has never been more pressing. The rise of cyber terrorism, extortion, coupled with the need to protect this value of data is a very real incentive for companies to get their data security right. As we M&A lawyers very well know, deal value protected is deal value realized. It is in this context and backdrop that I will now request our speaker for today, my partner Supratim Chakrabarti, who specializes in data security and data privacy, to lead this discussion. All those of you who've registered for this webinar would have received Supratim's credentials. Suffice to say that Supratim is an industry leader and recognized as an expert in this space, having advised various stakeholders on data, its nuances, and its implications. Without wasting any further time, Supratim, over to you to lead us into this very interesting presentation.
Thank you so much, Surbhi. Thank you everyone for joining the session. I will straight away jump on to the presentation. So I think before we start, this is a snapshot or India statistics on where we look at India from a cyber and data security perspective. Well, in 2018, India had one of the largest data breaches in the world. Between October 22 to March 23, Indian organizations had were on an average subjected to about 1,787 cyber attacks versus a global average of 983 per week. So it's almost a double, I would say. In 23, 73% of Indian organizations were exposed to ransomware as against global average, and I can go on. And all of these also have impact on transactions, M&A transactions, and otherwise operations of the company. We are all aware of the famous DraftKings, SB Tech, and DEAC merger, where in the middle of the merger, there was a cyber attack, which was reported, and about USD 30 million was kept with SB Tech as in escrow in order to fulfill any damages related claim that would have been made. So with that, the next important point is what is the kind of data that any organization holds at any given point in time? It's very important when you are looking at an M&A transaction and we are thinking about an analysis from a data security, cyber, or data privacy protection perspective. What kind of data does that organization hold? Okay, on the right hand side, you will see that large bubble. That's confidential data. It can be your know-how, it can be trade secrets of your organization or that of your customers, so on and so forth. And how do you protect it? You will be having technological measures, you will be having contractual measures, etc., to insulate this data. On the other side, you will see there is personal data. Now, what is personal data? Personal data is basically any data which is relatable to a natural person. Okay, most of the data privacy protection related laws would cover personal and sensitive personal data. Cyber laws cover everything. Just keep that in mind, whether it is confidential data, personal, sensitive, everything. Now, from an Indian perspective, on a sector neutral basis, when you look at personal data, the thing to be kept in mind is consent is king. You need to have appropriate consent when you are handling data, or say transferring data pursuant to an M&A. A simple example could be a business transfer arrangement or an asset purchase agreement where a data set of customer or employees is moving from organization A to B. The point to be looked into is, do we have appropriate consent? Okay. And then in the center is sensitive personal data. Now, these are higher threshold data, personal data, like say financial information or health related information, etc. You have to be more careful when handling this because the law, even on a sector neutral basis, calls out additional requirements to be followed, okay, in relation to its security, the kind of consent that is to be taken, the policies that should be in place, so on and so forth. And when you structure a deal, you would understand that probably if it's a consumer facing business, you would have more of this personal or sensitive personal data which you need to take care of. On the other hand, if you say have a non-customer facing manufacturing type of business, you could have more of this confidential data, which is more of know-how, trade secrets, etc. So you have to curate your entire plan accordingly, right? The next important thing is to understand what do we have as a law in India today, okay? And the reason why I'm also talking about it is because it's a slightly volatile situation right now. And like any other aspect or avenue, even M&A is impacted because of the volatility in the law that we are observing. So firstly, there is no exclusive legislation, which is a good and a bad thing, because there is not one book that you can just refer to and be happy that I have understood everything that was required to be understood. It's a patchwork of laws, okay? On a sector neutral basis, you have the Information Technology Act and the rules, which calls out primarily two things. One is personal data, how it is to be handled, and the other one is sensitive personal data, if it is involved, how that is to be taken care of. Then comes on a sector specific basis, you will have the sectoral regulators. And these days, sectoral regulators, both on the cyber, data privacy protection front, have become very proactive. You know, the number of guidelines, guidances, notifications that are coming out is unparalleled. For example, the Reserve Bank of India gives its diktat to banks and NBFCs as to what is to be done on the cyber and data side. Similarly, the insurance regulator, IRDAI, gives its diktat to insurance players as to what is to be done in this space. So you have to be very careful, even in an M&A deal, to understand that is there a pre-clearance of some sort required? Is there a dialogue or conversation with such a sector regulator important? Sometimes this could be relevant because there is no clarity in the law itself. In one of the recent matters that we did, M&A transaction, which was between two banks, we had to actually approach the Reserve Bank of India and informally get some blessings in relation to the activity that was proposed to be carried out in relation to data. So this is a very important pillar, I would say. And whilst we are waiting for all of this to happen, okay, there is supposed to be a upcoming data law, which is called the Digital Personal Data Protection Bill. On the cyber side, things have become super proactive. The CERT-IN, Computer Emergency Response Team of India, which was at one given point in time a very dormant player, I would say. We used to assist our client in doing reporting for any cyber breach. There was hardly any response back. But now we have a situation where CERT-IN itself is going to the dark web, taking snapshots of Indian companies' data being up for sale, coming back to those organizations, sending emails and asking questions. Number one, did you report this to us? Question number two, did you report to the impacted users? We have also had situations where the CERT-IN actually has sent show cause notices. You know, you would remember 1 year back, in April 2022, the CERT-IN came out with a direction, which amongst other things said 6 hours breach reporting. Now, this is a very strict and stringent requirement. 6 hours is too short a time to fathom what has gone wrong, do the reporting, etc. And everyone interpreted it the way they wanted. Right now, we have several organizations who have received show cause notices because they were delayed in making those filings. In the M&A space also, we have observed a lot of touch points on this. For example, the target thought that a particular incident was not reportable. But when the due diligence was happening for the M&A, it was figured out that it was indeed reportable, which was not done and definitely not done within the timeline. So you can imagine how complex it could become. It is becoming now, not only on a sector specific basis, but also on a sector neutral basis. CERT-IN is applicable across the board for all type of organizations. It does not matter whether it is personal data, sensitive personal data, or simple confidential data without any personal or sensitive personal information, etc. And then we have a situation where we are looking forward to more comprehensive and robust laws. For example, the Digital Personal Data Protection Bill. Presently, you have a provision in the Information Technology Act where the damage to your kitty could be to the tune of 6,105 USD. That will now become about 61 million USD. So you can imagine it has become a board level discussion and discussion in any M&A or prospective M&A that are we kind of future ready for this law which is coming, because the damage could be really big. So, and we also have another law, which is the Digital India Act, which is supposed to rewrite the entire Information Technology Act. And this will have things like AI, etc. covered. So overall, in a snapshot, I would say we are in a volatile situation. A lot of movement on the cybersecurity regulation side, definitely, and also on the data privacy protection side, we are observing a big shift towards a larger quantum of penalty and a lot of compliances. So from an M&A perspective, when you're looking at any deal, do keep these things in mind. The next important thing now is to break an M&A exercise into bite-sized pieces, okay? And what we have tried to do is create 4 phases of an M&A exercise. In mergers and acquisitions, typically, the first phase will be the deal structuring, okay? You know, you'd remember earlier, there used to be a lot of time spent in tax structuring before one jumps into an M&A exercise. Right now, what we are observing is that significant time is also being invested in doing data structuring, okay? Especially say where there is data movement to occur, okay? You need to understand, say in a BTA scenario, business transfer or an asset transfer, where a database is to move from entity A to entity B. Do we have significant, like the correct kind of consent that is required to move the data set from A to B? Otherwise, you could be acquiring this asset, which would have zero value, or something which could actually expose you to more liability. Then you have cross-jurisdictional data migration requirement pursuant to a particular transaction. So all those things, I will keep talking about it throughout this presentation. But data structuring, including system integration, cyber side of things, all of this is a separate pillar which needs deliberation beforehand. Then comes populating data room. Now, why we have talked about it here is also from the sell side, okay? what we observe many a time is that a lot of data is just simply dumped into the data room for the acquirer or prospective acquirer to look at it. For an example, like you will see there will be an Excel sheet with all the employee names written, and against their names you will have what salary they're getting, what is their bank account detail, etc. The question is this really required to be given in that manner? Answer could be no. You can have bands of employees provided and the salary that they're getting. That could be another solution, and there could be many. Okay, we are trying to ring fence the data appropriately, even from the sell side, so that they are not overexposed. Sometimes we have seen that some contracts required prior consent before it is divulged to someone, but those consents have not been taken, and it's straight away put in the data room for any of those prospective acquirers to look at it. So these are actually non-compliances which you are inviting, which you should be careful about. From the acquirer side, I would say, at least on paper, ensure that you have taken a sign off from the target or the sellers that nothing which is contravening the law or any contractual provision will be really showcased in the data room. We would not like to take liability or responsibility of that. Then comes due diligence. I think this, let's spend some time, because the mother of all things that we will do, I think, is sitting here, and we should spend adequate time in understanding this due diligence exercise. And it is not a generalist's job, not someone who's regularly dealing with M&A, I think should be handling. There should be some specialist attention given to this. The first pillar, I think, here is understanding the industry and the sector. Some industries or some sectors could be having very critical data sets. For example, healthcare, pharma, banking and finance, etc. These could be housing data sets which are very sensitive, both from regulatory and from a personal data perspective. There are certain industries which are actually very vulnerable. Interestingly, manufacturing is considered to be quite vulnerable because usually the IT systems, security systems are not very robust, and we have seen many ransomware attacks, etc., happening during the COVID time, especially. And therefore, it's an important pillar of due diligence, that you understand the industry and the sector very carefully, get in sector specific specialists if required, who understand data housing movement related aspects. The second thing is kinds of data handled. Do you have sensitive personal data? Do you have personal data? Or what other kinds of data are there? And accordingly, you will have to curate a plan, because your job does not end with the diligence and just drafting a share purchase, a share subscription, or a business transfer arrangement. It's after the deal happens, what happens to the data? It gets into your system. Sometimes these the computer resource and network systems also come within your fold. You would not like to have a situation where you are inviting trouble and getting a compromised system integrated into your own system. So very important, we should sort of pay attention to the kind of data handled. Next is jurisdictions involved. Every jurisdiction right now, almost every jurisdiction has a specific law on data, cyber, data security, etc. What you have to be mindful of is what all are the laws that are getting triggered. You could have a situation where you could be inviting a harsh penalty without even knowing that you are going wrong. During the COVID times, say some of the edtech companies proliferated from India and went across the globe, having operations in Australia, Middle East, US, everywhere. And then we saw that they were handling children's data in these jurisdictions without even knowing what kind of regulations apply there, what are the compliances that are to be followed. So it's important to know the jurisdictions that are involved. There could be a situation where you might be sitting in India, but you're handling a lot of EU data or any other jurisdictions data. Are we really following and kosher from that law's perspective? So important, very important pillar, especially in today's day and age. Next is cyber and data related policies and practices followed. Like I mentioned, certain talks about a 6-hour breach reporting. In 6 hours, you would not even know what exactly happened. So your SOPs, your playbooks in relation to policies and practices, all these should be absolutely streamlined. You can't be thinking at that hour what we should be doing. And this gives a bird's eye view to you as to how the organization is. And when you are doing a due diligence, I would recommend that you keep talking to the technical cybersecurity team which is doing diligence, because exchanging notes will help you. At times, we have observed that the policy has been probably copy pasted from somewhere, but the practice is very different. So this marriage is very important. So a lawyer should be wearing the hat of a technology guy as well, and at least trying to have that conversation with your own diligence team, which is looking from a cybersecurity IT perspective. And you can also have an open dialogue, wherever, depend on feasibility, with the target and their team who are looking at it from a IT cyber side. Then comes previous cyber incidents or data security incidents, extremely important. And I'll club this with the last point with regulatory and counterparty communications. Prior incidents are important to be analyzed because this could have ramifications in future. It could have claims in future which you need to perhaps insulate against. And at that time, what kind of communications happen with the regulator? Say, for example, the certain, whenever there is a ransomware attack, nowadays asks that you please go and file a police complaint with the law enforcement authority and give us a copy. Many a times organizations shy away from doing that activity because when you report to certain, it is more or less confidential. But when you go to the local police station, probably it will be made public. That's a fear that people have, and they do not complete that leg of the requirement that is come from certain. So in a nutshell, it's important to see all those communications and understand that whether all the asks that were there have been really followed. Also, regulatory and counterparty communications. In one of the situations, it was so critical, like it was an app-based business and it was completely shut down by the cloud service provider because they said, there was, crypto mining, which was happening for very long, and they had flagged it out, which was not taken care of. There were other issues also, we are not getting into that. But point is that if these are not open, perhaps the item which was the lowest in your requisition list of due diligence becomes a business stoppage or showstopper in a time when you have actually acquired the business and you're trying to run the show yourself. Moving on. So again, just on the diligence piece, other things that are there. One is data flow. If you are a cyber data lawyer, you need to understand the data flow very properly. Okay, where all is it moving from? You have a cloud environment, you could have in-prem environment, etc., or a third-party application. The data movement will help you to understand what questions to ask. Do not just simply pick up an off-the-shelf requisition list and send it and just stop at that. There could be further investigation, introspection, which would be required. Next is, I talked about it, international data transfer. There could be additional requirements, say a standard contractual clause or BCRs and things like those. But when you have international data transfer, ensure that you have those specialists on board who understand international or cross-border data transfer. Next is assess the vendors and third parties who might have access. Simple example, say a payroll vendor or service provider you have at the back end. You are thinking that your organization is fully insulated. Suppose that vendor has a very poor cyber infrastructure. You could be actually leaking the data from their end. Or suppose that vendor gets acquired by a competitor. Do you have enough contractual measures to show that, okay, if there is a change in control or any investment or selling of business, you'll have to take prior permission from me? Most of the times we see that these are seen to be so insignificant that these are not there in those agreements. Anyway, so then comes identify the representations that you've made to individuals. Many a time there are reported judgments actually in foreign jurisdictions where a particular entity was actually not found falling foul of the law, but what they had written in their privacy policy or terms of use, they were actually not following it. Okay, so sometimes again there's a lot of copy paste business which we observe, but what you are actually doing with data, with the cyber aspects, is very important. Then is the consent framework with the customer. Suppose in certain jurisdictions pre-ticked boxes are not allowed, and you have the entire data set that you have from data of individuals is procured through those pre-ticked boxes mechanism. The entire data set would be turned futile. And finally, the most important thing, what is your recourse against the target or the sellers in an M&A transaction? We have seen situations where the deal has happened and then there was discovery of certain incidents, what is your fallback mechanism? For how long can you go back and really claim that amount from them? This is, I think, one of the most important pillar when you're crafting this entire deal. The next phase is assessing the due diligence outcome. So once the diligence is over, what are the takeaways from there? How do we really handle those takeaways? I'll talk in a little more detail in the next slide. Then comes drafting transaction documents. This could be your share purchase agreement, shareholders agreement, business transfer arrangement, or even transition services agreement. When the new acquirer comes, perhaps they are not fully aware as to how to handle the situation. So many times we have seen on the data, on the cybersecurity side, there is hand-holding required from the target. Be very careful who are those individuals who are giving you the transitional services, okay? There have been times where in the interim between signing and closing, there have been data theft by employees who got very scared probably that my job would be gone. So just flagging out that these are important things to be thought of at that juncture. Then of course is negotiation and finalizing of and signing of the agreement. So assessing the outcome of a due diligence, what all you should be keeping in mind. There could be significant cyber liabilities. We just talked about DraftKings, SBTech, and DESE, where you could have actually, escrow mechanism which is required, or deal value adjustment, or holdbacks which could be required. Then have specifically curated reps, warranties, covenants, indemnities, or specific indemnities. Again, please do not pull them out off the shelf and try to keep it as broad brushed as possible and think that will help. You may require granular detailing in some of these pockets. Then comes understanding condition precedents and subsequent. Data movement and transition is not a very easy thing as it seems from a lawyer's perspective, pure lawyer perspective. When you look at the technology that is involved, for example, in one of our transactions, the consent that was required to be taken from the customers was a 1-year process. And then basically transitioning them properly to a sector regulated entity was another challenge which we had to really think through. So it's a proper thinking process which has to occur for such transactions, at least on a sector specific basis. Then you have to negotiate the limitation of liability thresholds and exclusions carefully, because there could be, like I mentioned, there could be threats and risks. And finally, is there a requirement to have specific cybersecurity insurances or DNO liability insurance or WNI insurance? You need to think about those as well. Then comes phase 3, which is pre-closing. Between signing and closing, you will have that phase where you will plan, mostly what to do with data systems, cyber related insulation, and then you have standstill provision. Okay, between signing and closing, you should not be doing certain things. We have seen many a time between signing and closing a lot of cyber incidents happening. How do you sort of report what all are the actions to be taken, and then closing happens? Okay. Staying on few of these points, the transitional obligations. One of them is do not take any significant, steps or actions which in relation to data privacy or cybersecurity without, of course, the seller, the acquirer knowing about it, because it could be very different from the plans that the acquirer could have in future. Then, if there is any incident which occurs, you have to cyber incident which occurs, you have to immediately notify the purchaser, the investor, and maybe jointly understand what should be the step and go ahead and take those steps. There are many international precedents in an M&A scenario where deal value adjustments, a lot of issues were there when at the last moment, say in the disclosure, a surprise was sprung that there was some cyber incident which occurred, or between signing closing, like I was mentioning, some employee ran away with some confidential company data, etc. Then comes some other important consideration which can occur either as a condition precedent or a subsequent, or it could be a running phase. This could be integration of computer systems and migration of the data. It could be notification and registrations with the regulators, or informing the data subjects, or even revising some of your existing contracts. Very important to keep in mind. Then comes phase 4. Okay, this could be there or may not be there in certain cases. These are post-closing activities, transitional services, like I told. And then there could be data usage or database integration related activities. And sometimes what we observe is acquirers take the data and try to, say, cross-pollinate into their ecosystem for upselling, cross-selling, etc. So post restructuring, what do you do with data and cyber related aspects is important. And the thinking actually starts at the beginning only, where we do the data structuring and the deal structuring. So with that, I come to my very last slide, which is actually encapsulating what we discussed till now. We need to assess the sector or the industry carefully and structure the deal. You need to have specialized due diligences. And I think all the tips I have already given you through this journey of the presentation. You need to make careful decision in relation to due diligence findings and risk mitigation strategies that are there. We have to craft representations, warranties, covenants, indemnities in a specifically curated manner. Then you will have pre-signing activities and signing. Then you'll move on to some conditions precedent to be fulfilled. This could have a planning phase of what to do with data, system migration, integration, and then goes to the next phase when you'll have closing and post-closing activities where you actually execute such system migration and integration, and you could have transitional services which are actually provided by the seller side or the target. With this, I have come to my end of my presentation. Thank you for listening in. I'm now happy to take any questions that you might have. Over to you, Surbhi.
All right, thank you, Supratim, for those very interesting oversights and insights on cyber data security issues. It's actually far more complex than we M&A lawyers envisage. I would now like to invite our audience for some questions. Please use the portal and the facility on the portal to send us your questions. We already have a few questions, so I will start on those questions, but do keep those questions coming in. Supratim, I mean, you mentioned dark web, and I for one thought that dark web was just a tool restricted to Black Mirror type platforms and the OTT platforms. But what sort of security measures would you recommend sellers to take to safeguard themselves from what's happening on the dark web, or sort of exposing themselves to any sort of attacks from down under?
Right. So I think, of course, the possibilities are endless from a seller side, and I think there's a good question, Surbhi, because whilst we have focused largely on the acquirer side, from the seller side also there are a lot of things which one can do in order to insulate themselves. One is that, whilst the law may not be calling out a specific standard, but the global gold standards are already etched, and industry standards at the minimum should be followed. If there is any incident, I think you need to have SOPs in place and you need to attend to it. And when you have a transaction, it is better not to hide things, but to be transparent about what has transpired. That way, two things will happen. A, there will be no heartburn, there'll be no pain point right at the end of, at the time of closing of a transaction. And in future, if there is any liability which occurs, you would not have to shell out money on that day. So I think it's better to be upfront. And when you look at rep, warranty, covenant, the insulation mechanisms which are available today, those should be thought through appropriately from a seller side. I'm not getting into the technology aspects of it because I can go on and on.
Of course. The one very interesting question that we've got from one of our audience members is, Sam Altman was here earlier this month, of course, and he met our Prime Minister here. What do you think, are the challenges that companies, target companies face in view of increased interface with AI and the likes of ChatGPT? I mean, ChatGPT is, of course, a very evolved form of AI. It may not be the case 1 month later, who knows what's going to come up. But when we talk of AI and when we have bots which sort of accumulate data through various sources, some of it may not even be known to us. If you're a target entity and you're looking to stitch an M&A deal, what should you be doing, particularly when you're dealing with AI as something that's out there?
A very good question, Surbi, and very topical. I would say, AI and generative AI is here to stay. So from a target perspective, it is better not to stifle it. Some organizations would go ahead and ban it, etc., unless you are in a very sector specific area where it should be done that way. But otherwise, the way I look at it is you can create a safe space for your employees to actually look into things without really compromising the data of the organization. We are all aware of the Samsung incident where the employees were actually trying to get an output from the from ChatGPT, and they actually sort of fed in data which was company confidential data. So therefore, I think the way out is a middle of the road approach where you create policies around it and allow innovation to flourish. Okay, there could be safe zones which could be created, policies which could be put in place, and pursuant to that, you can allow these things to happen. Also, this will create a good picture when a prospective investor is looking at it, that such kind of policies are probably not very, openly seen these days. So you would be one of those first ones who could project it, that we already are ahead of times.
Absolutely, ahead of times is the buzzword. Moving on to at least we as M&A lawyers have always believed that India has what we call a two-party consent framework when it comes to collection and dissemination of data. You earlier in your presentation touched upon, assets, if I recall correctly, assets having zero value. Does it mean that now we are moving away from that two-party consent framework? I know some states in the US have a one-party consent framework as well, but India has a two-party consent framework. So when you say that assets having zero value in terms of data, how do we safeguard ourselves? One of our audience members also has a similar question as to, when customers are either silent or they don't give consent. Are we moving away from the two-party consent framework here?
So I have a good and bad answer basically for this. The difficulty is that today, unfortunately, our laws are that two-party consent driven. Okay, you have to have consent in order to do anything. In fact, you won't believe that even if there is an employee investigation happening, if you read the black letter of the law, if say the laptop has some sensitive personal data of that individual, you technically should have the consent from the person to look into his sensitive personal data. So that's the type of situation that we have today, and we are trying to move away from it. Okay. So in more refined jurisdictions, you have more grounds of processing. Like consent is one ground of processing. You could have many others. You could have legitimate interest. You could have emergency. Like a patient is going to the hospital and fainted, you would not take consent from the guy to operate that chap. So therefore, one of the ground which we were trying to think of is M&A. Thankfully, after a lot of deliberation, it has found place in the upcoming Digital Personal Data Protection Bill. It's not worded very happily. It has to be refined from a language perspective because it has got parked under public policy and all of that. But point is that M&A, there has been a portion, and thankfully the government has heard it, is going to be an avenue where if that goes through, then that is considered to be deemed consent. So you need not go to the data subjects below, to the customer, to the employee, to again ask for consent in order to move that database from entity A to B because there is a restructuring or an M&A happening.
Understood. Supratim, we've also talked a little about data localization. Where are we in terms of data localization in India in M&A deals, and where do we stand so far as data localization is concerned?
Yeah, no, I'm aware, Surbi, that it is like heart of many deal conversations is on data localization, of course, because the acquirer could have aspirations to take data outside, etc. So very interesting times in India right now. We started from a position where the government perhaps thought of hard data localization. The earlier version of the data bill had that, but now the present version, I think, is a little more relaxed, and they are talking about whitelisted jurisdictions. So data can be shared with whitelisted jurisdictions, provided there are some terms and conditions, etc. There is also rumor that this could be turned into a blacklisting concept, that you will only have few jurisdictions which are blacklisted, and apart from that, you can actually share the data with any jurisdiction. So when you look at from an M&A perspective, I would say on a sector neutral basis, it could be better than what we were thinking earlier. On a sector specific basis though, some of the regulators are still trying to guard and keep data within the country. Simple example, payment systems related data cannot leave the country. I think Reserve Bank of India took a very, very hard stance on that, and they continue to maintain. So that's a snapshot.
Thank you, Supratim. Moving on, and we're getting a lot of interesting questions from our audiences, and a couple of them actually go a little bit deep into the tools that we M&A lawyers use typically when we talk of buy-side protection clauses. So a very common tool that we talk of is seeking indemnity from sellers and from companies. When you talk of data privacy, when you talk of cybersecurity, when you're talking of data as an intangible asset, what would your advice be as a buy-side M&A lawyer to your client when you talk of negotiating thresholds? Is it possible to quantify that in certain objective terms, or is it difficult to quantify right now? And would you argue to sort of have that as an unlimited dip, or would you prefer that this would also be categorized as an operational representation? One of our audience members actually has a question on that.
Again, good question, and even I think every person who's doing M&A, I think this will pop up as a question in their mind. See, the point is you have to assess the sector, the kind of data handle, the real exposure that you are observing. In some very well guarded and regulated sector, this probably needs to be looked at a little more minutely. Okay, especially if there are instances which have happened in the past, the kind of damages that had to be paid out, etc., that could work as kind of a benchmark. But what we are also observing is that the trajectory is going up. Okay, one of the provisions in Indian law under the Information Technology Act is in relation to sensitive personal data, like I was mentioning, and it says that damages are payable by way of compensation under that kitty. Usually, what we have seen is you would have disgruntled employees or rogue customers who would trigger this, and they would go to, say, adjudicating officers of the state or to higher forums and say that my sensitive personal data has been looked into, I need relief. We've had situations also in an M&A situation that how could my data go from A to B? I had not specifically given any consent, so do not assume consent. So we have devised some methodology. So coming back to your question, so I think when you're crafting this, firstly you need to see whether it is at all quantifiable. If not, then I would say look into prior instances which have occurred, and keeping that as a baseline, think about protections that you might need. It can start from, say, holdback to escrow. It can go up to say a clawback later on. Various modalities could be sort of thought of, but it again, I'll go back to my point on the industry, the sector, the prior instances, and keeping in mind that this is becoming a more risky zone as compared to the past.
So effectively what you're saying is it's the quality of the diligence and quality of data protection that a seller or a target employs that will dictate what sort of checks and balances we as buyers should accept.
Yes.
Absolutely. There is this whole thing of data retention and data destruction when you talk of confidential data or any data which has a significant value in an M&A deal. Is there any, and this is from one of our audiences, is there any mandatory data retention period in India under the current regime or in any of the upcoming laws that sort of prescribe for how long should I keep the data? Is it relevant in M&A deals?
Yes,
this is maybe more from a diligence perspective when we look at what is the quality of
the
data
look-back period. Yeah,
That's
also the look-back period, etc. No, so I think this is a good question. So when you look at most of our laws in India, it does not have a hard timeline as to how long the data should be retained. Okay, in fact, the few provisions which are there in the Information Technology Act, one of them has a purpose-oriented retention being mentioned. That so long as you require it for the purpose, you can retain that data. However, there are some others where because of industry practice, etc., there are some timelines which have kind of become the norm, and that is followed. What we see organizations is they have a retention policy, right from their business emails to communication with employees to litigation hold matters, etc. What are the timelines to be followed? I would recommend that to be followed. And going forward also, the we'll have to, it's not hard coded. I had a discussion with the relevant people in the ministry that probably when our new law comes in on data, some inward looking activity should also be done by a government to bring in as much of data minimization concept into the legislations as possible. So your labor laws, for example, if they come with a cutoff date of storing data, you would actually be keeping less data and therefore be less exposed to cyber attacks, etc., for that data.
Speaking of cyber attacks, and as M&A lawyers, there are new tools that buyers and sellers often deploy to safeguard themselves against risks in a potential M&A deal. Those risks are at times shared, and one of the most popular and up-and-coming tools is really of indemnity insurance or rep and warranty insurance and tax insurance. Where do you think these products are in terms of safeguarding any unknown cybersecurity risks? Are these prevalent? Are you seeing, because I'm aware that you're advising several of us on our M&A deals as we speak, and are you seeing these products, insure for cybersecurity risks? Our audiences are very keen to know this.
Yeah, so the short answer would be yes, we are observing a lot of tools, a lot of these innovative policies which are coming. But till now, I think it's still at a nascent stage, is what I would say. It's still evolving. And the protection that they provide is, I would say, not as robust as maybe in probably in other jurisdictions, etc. And the carve outs or the process that is followed to reach to that level of what is actually payable is probably not as comprehensive a protection as one would expect, right? Firstly there will be checks around what is there as practices, policies, past instances followed, and then the unknown basically is what is covered, and that also over and beyond the policy that you already have. So many a times we see that we hardly reach that threshold. When you look at that waterfall, I don't know how many in how many cases will actually reach that position of actual payouts. Having said that, I've heard that there have been some payouts, not in my or our cases, but yes, it's now being heard of.
Supratim, that we have a fair amount of students and aspiring lawyers who are part of our audiences, and they have some very interesting questions. I'll just take the liberty to ask a few. I think we just have a few minutes left. One of our young members are asking that what is the role played by internal policies of global MNCs, and what impact will they have on future acquisitions, especially in the tech sector, where the asset itself is nothing but data, data accumulation, data is dissemination, data utilization. So, as a data privacy lawyer, uh, what would your advice be to Indian companies in view of privacy policies of these global tech giants?
Right. So I think if I've gotten the question correctly, it's basically adoption of the global gold standards or policies into the Indian ecosystem. Okay. To my mind, yes, I think globally the gold standard has already been etched as far as privacy and data protection is concerned. That should definitely be adopted to the extent possible by Indian organizations. We have had hilarious situations I was mentioning, not very directly, but where clients have come and said that why don't we copy paste from our competitors website and just simply put something together. And one of the requirements there is a data subject related request to be responded to. So my question was, do you have a mechanism behind that if someone makes a request for right to be forgotten, right of erasure, or right of rectification, someone in your system will be attend to it? And the answer was no. So I said, then how can you write it in the policy, which is an outward looking document, and get actually beaten by what you've written yourself? So simple example, but I think it's about time that we start adopting some of these global gold standards.
Absolutely, absolutely. And talking of global gold standards, our regulators, as you noted in your presentation, have become far more proactive than, let's say, they were. And you spoke about certain, and you spoke about show cause notices being issued by certain. Now, if I am a lawyer for a buyer and I'm advising them on an M&A transaction, and as part of the diligence, I come across certain show cause notices that have been issued to my target. What should I recommend to my buyer? I mean, should I say that we need to see the notices to its fruition? What is the resolution in terms of practical terms? What are the next steps that one should be taking when there are open certain notices?
So I think when you see a certain notice, definitely you should go to the depth of it and figure out what was that instance which triggered such a notice. Okay. Right now, the spectrum of certain notice is pretty wide. It starts from a very minor breach, which could be an employee who was not authorized, took access, etc., up to ransomware, right? So we need to understand that what is that category of cyber incident that has been spoken about. What was the measure that was taken, if at all any, and if it remains open, definitely a communication with the authorities with all apologies, because like I told you, show cause notices are being issued. Right now, what we have observed is no punitive action has been taken, but this is basically a precursor to that. So it's a right time, if you're observing right now anything, it's a good idea to go back to the authorities and apologize and say, this is what we have done to cure the issue, and it stands resolved in this manner.
Right, Supratim. We have a whole host of other questions that are coming in, but I'm cognizant of the time constraints. I would like to let our audience know that we've got all your questions and we will respond to them via email post this session. But Supratim, just to in terms of if I were to ask you to summarize the top 5 takeaways from a cybersecurity and data prevention aspect and its significance on M&A transactions, what would your top 5 takeaways be for our audience here, just to summarize our discussion?
No, I think I'll summarize the way I was mentioning previously. I think that deal structuring or data structuring is very important. One size does not fit all. You cannot have an off-the-shelf requisition list just given and that's the end of the story. You'll have to understand the sector well. You have to understand the data handling, the kind of data handled, cross-jurisdictional aspects, etc. So that's very important. The pre-work that you do. Okay. Then is the diligence. In diligence also, I think there's a bit of a pre-phase and a post-phase. Okay. So pre is understanding what kind of questions to be put, etc. What's to be looked into, the actual findings, and then what do you do with those findings. Okay, that's the second thing. The third thing is what goes into your document, how that has to be sort of curated, and the insulation mechanism that you build in. Okay, that negotiation, etc. Then comes the next phase, which is the closing. And at closing, what happens? Earlier we used to have like a same day closing. The more complex data related activities are becoming, the same day closing is becoming an impossibility, because the transition itself takes so much time if you have to do it properly. And then the last thing is the post closing and the any transitional services, anything that you require post that, any support that is required from the sell side. Remember, they have sold at the gain getting out, so you don't know what kind of employee mindsets are there for the people who are helping you out with the secure cyber security and data related aspects. So this, you have to insulate yourself through and through. I think if you ask me, these were the top 5 that I could think of.
Well, thank you, Supratim, for your thoughts and for your mind space on this topic. I think my takeaway as an M&A lawyer is that it's important that we onboard the experts. Data privacy, data security are not to be taken lightly, and they can have far-reaching ramifications in M&A deals, both from a diligence perspective, from a documentation perspective, from a post-closing, and from a risk-sharing perspective. So thank you so much for your thoughts. Before we conclude, Mitesh, may I request you to please project the poll slide? I would request our audience members to spare about a minute to vote on the poll slide that is visible on your screens. Your feedback is extremely important to us. We take this very seriously, and we will use this to further curate and even better our webinars. In conclusion, thank you, Supratim, for taking your time out and sharing your experience and expertise with us. To our audience, I do hope you found this webinar interesting. We'll be bringing you several topics which are relevant for M&As from an India perspective as we move along. We are middle of the year. We have a few very exciting topics lined up, so keep watching this space. I do hope you enjoyed this webinar and we were able to contribute to your knowledge. We certainly enjoyed bringing it to you. We will send you a copy of this presentation along with summary notes and a link. Post the webinar, you will receive a request for feedback. Once again, I would request you to please give us your feedback. And please do not hesitate to contact us if there are any further questions that you have or any further information that you need from us. Once again, thank you so much, everybody, for joining us. Have a good day and have a great week ahead. Bye-bye.
Thank you. Thank you all.